Yes, Mr. Howard.
My lords, I appear in this matter with my learned friend Mr. Gethin Thomas for the appellant. My learned friends Mr. Mark Westmoreland Smith, King's Counsel, and Mark O'Brien O'Reilly appear for the Secretary of State. And my learned friends Mr. Michael Humphreys KC and Miss Isabella Kafur appear for the second respondent.
Thank you.
Who are River Road Strategic Partners. The court should, my lord, have a core bundle, a supplementary bundle, and a bundle of authorities.
Yes.
And within those reference skeletons.
Yes, there's also a short application bundle concerning the York Aviation document, which we've also seen. Yes.
My lord, in terms of the documents, can I just hand up two documents you think are helpful for the court to have?
These are ones that are on the bench.
Yes, so my lord should have, there's a letter of the 30th of July 2021 from the Secretary of State, which is referred to in the judgment below, and it's on the skeletons, but with apologies hasn't made it into the bundle. Okay? I helped report that. And then, my lord, there's the judgment of the Privy Council in trial camp, which is referred to, but didn't make it into the authorities. I think that's all the preliminaries.
Thank you.
My lords, in this case, the Secretary of State has twice rejected the views of his examining authority on any need for the reopening of Manston Airport. And he's also rejected the advice of his independent aviation assessor, whom he'd appointed to address the question of need. Now, of course, my lords, in principle, the minister can disagree with those he's appointed to advise him in these processes, but of course he must do so lawfully, and that's the responsibility of these proceedings to consider. And the minister acted unlawfully for three reasons. First of all, he was unfairly relied on the azimuth report when the evidence that the report itself relied upon had not been disclosed to anybody, and so was not able to be scrutinised. Secondly, he acted in breach of the rules and unfairly in failing to consult on the IBA report, which had been submitted during the course of the redetermination process. And the third point, my lords, is that the Secretary of State, or the minister dealing with it, in reality, the minister had been unlawfully advised that he could not take into account future capacity at other airports.
So one is A, two are B to D, and three
yes,
is B.
Yeah. As my lords will have seen, the grounds B, C, and D sort of run through. Essentially, what I need to demonstrate in respect of those three grounds, the IBA grounds, is that the Secretary of State should have consulted or allowed the opportunity for representations on the IBA report and failed to do so.
Right, and is it your case that if you were to get home on one of those grounds, that would be good enough?
Not quite good enough on its own, my lord, because, for example, the way we phrase ground B is the interpretation of the rule. Does Rule 19 apply? Now, if Rule 19 applies, I of course need to go further. So if Rule 19 applies to the redetermination process, I need to go further and to persuade the court either that in this situation, the Secretary of State should have raised his disposition to disagree with the examining authority on the basis of the IBA report and invite comments on it, or that for some other reason he should have taken that step, and also to show that there wasn't the opportunity to do so. So there may be a number of different ways in which I can get the final result between B, C, and D, but B itself doesn't get me home on its own.
Right, but in full answer, do you contend that either 1 or 3 of your numbered grounds does?
That's my lord. One of them.
If you look, I've noted them as 1, 2, and 3 because we're concerned with 3 topics. Number 2 has some subparts to it, understood, and you dealt with that. But taking the first and the third argument that you make, is it in general your submission that if you were to succeed on either of those, that would mean that the decision was unlawful?
Yeah, yes, my lord. So, in respect to whether if I get home on 1, 2, or 3, I only need to get home on 1.
One of them.
One any of those 3.
Right. That's all I wanted to know.
My lord. So, my lord, what I was going to, unless there are any points on the background which I was going to go straight into the grounds.
Yes, please.
So, my lord, turning to ground 1, which is the Azimuth report.
I'm sorry to interrupt you once again, but just because we don't happen to have a template in front of us. Essentially, this is a two-sided argument, although you have two opponents. What's your general map of the morning? How long do you expect that you'd like to take?
My lord, I'm seeking to finish by 12:30, so within 2 hours. That will then please my learned friends.
My lord, and then I intend to finish by 3 o'clock, giving my learned friend an hour, and Mr. Harwood half an hour to reply.
Yes. Well, I think, as I've said, it's a two-sided argument, and so you shouldn't consider yourself rushed. If you finish any time this morning, that will be fine. I'm sorry to see that the clock isn't working.
My lord,
we have other ways.
We have other ways. My lord, I have my watch out. But my lord, in a sense, whilst of course there's a huge amount of material which has led us to where we are today, the points which I'm raising are points which are relatively straightforward, or limited amount of material which is critical to that. And what I seek to do is to get those points over quite quickly, because either I succeed on those or of course up with them. But what we are demonstrating is that this process of Secretary State's disagreement with his examining authority ended up being dealt with unlawfully by the minister. So on ground 1, Azimuth, the Azimuth report was drawn from 24 interviewees and other material, and we can pick that up in a couple of places, but take it from the examining authorities report, my lord, and that is in the supplementary bundle at page 719. And
would it be possible to give electronic references, because this bundle starts at something like 500. I'm using the soft copy. 719 doesn't get me to the right place.
I apologise, my lord. Will 181.
So probably do it from the index.
So this is where the examining authority is dealing with the applicant, forecasts, and Azimuth. If the court just picks up, apologise please, the page before, so page 180, and paragraph 563.
Five 653.
Yes, 5653.
Yep.
And there they pick up the source, and we'll reference it in papers to where there's an Azimuth. Interviews to 24, described as industry experts. Point on the next page, paragraph 5657, which the examining authority make, is that the transcripts have not been made available, described as due to confidentiality and commercial sensitivity. And that the view of the examining authority is that limits the weight to be given to those. To make the point that many of the interviews also appeared to be local businesses of limited size or pro-business organisations for Kent. The next paragraph deals with the other source of information within Azimuth. So paragraph 5658. And the applicant referring to various other interviews with other key airports, industry organisations, and so on, but didn't provide details of names, organisations, or content. So that is how the examining authority summarises the problem. If we turn to look at the Azimuth report itself, which is page 604 in the hard copy bundle, and that should be about page 65 of the PDF.
Thank you.
Which I hope for Lord Justice Warby brings up table 3. A list of interviewees.
Yeah.
And so these are the 24 interviewees. And then on the next page, paragraph 342 says that the transcripts have not been made available. And 343.
Well, you need to read the last sentence too. Responses have been incorporated into the findings presented in section 4, and then you need to read the whole of section 4.
Yes, my lord. I'm going to take the court to section 4 in a moment, just to look at how that material is presented. So then paragraph 343 is the reference to numerous other sources, some of which are identified there, and that's what the examining authority itself is referring to at 5658, which we've just looked at. If we go over to look at the findings at bundle 606, findings of section 4, what we find there, my lords, is that a lot of those findings are reported very briefly. So, for example, at question 2 which is at paragraph 414. Remember that there are 24 interviewees as well as other sources. We get an answer response saying the answer varied, and two examples are given there. Some of those responses, if we just sort of turn through the material, for example, to question 4, there are a variety of quotes, which in fact come simply from 3 of the the 24 sources for question 4 going over to bundle page 608. And then on some of the questions, so if we go please to bundle page 609, questions about the motivation to use Manston Airport, so questions 12, 13, 14. 12 and 13, 12 gives a reference back to what we just looked at in question 4. 13 is not informative of what people were saying, not different response. That's 13 and 14. Has one quote from Coin Airways. So to pick up the question, well, in a sense, is the information contained, is what azimuth we're being told simply set out in section 4, even if it's the original material, original transcripts or the email exchange that ought to have the advantages? Well, my lord's answer is no, it's not. There's some information in section 4, but a lot of that is very general as well. Particular questions, it comes only from, at most, a handful of respondents in terms of any.
But you know all that because the minister didn't have the information in the transcripts either.
No.
And the question is, what was relied on? Answer, this was relied on. Now, you may want to make comments that that's not good enough, that there aren't enough people, or the experience is limited, but that's nothing to do with having access to the transcript.
The fact of the matter is, my lord, of course, no one had access to that material. The examining authority didn't have it, the minister didn't have it, none of the participants, other than the interested party as applicant, had access to the material. Yet that was for a report on need, which was put forward as a critical part of the applicant's case, and the court will have seen from the Secretary of State's decision, is a critical part of the Secretary of State's conclusion.
I think the point that you have to consider is this: that this is not a complaint that no reasonable minister could have relied upon material of this quality. I mean, I could understand an argument built in that way. In other words, it's just too thin. It's not something you could really base a decision upon. But that's not the issue that is before us. The issue before us is a completely different issue, which is whether all the consultation that took place, because this is an old document, it's been commented upon repeatedly, and whether the very fact that there was undisclosed material, undisclosed to everybody, including the minister, means that it's an unfair process. So I wouldn't want it to be thought that we don't get your argument about the level of detail or the arguable qualities of this sort of report, but that's not the discussion.
No. And my lord, the case we've always put and are putting on this ground is not a case that the weight which the minister attached to the material was irrational.
No, but you could have done, but you didn't.
I'd also appreciate the difficulty the court would have in reaching a conclusion that the weight attached to a matter is irrational.
Yes,
and we're well aware of that point. And we're not saying that it becomes an immaterial consideration. Clearly, evidence in front of in the application process, in front of the examining authority, in front of the minister, on need is material. But what we say is, in these circumstances, where this is critical material, but where the underlying evidence is not available, that it actually becomes unfair to deal with that. And
your ground of appeal is slightly different. Your first ground of appeal is that the approach that the judge took was wrong because he considered whether the decision of the Secretary of State was rational, whereas it was a matter of fairness for him to decide. And the first question is, did the judge make that error? And if he did not, what's the role of this court then in determining fairness? That's the first question, isn't it?
Well,
Your ground of appeal?
Yes. And it is a question of fairness of the court, and the court's analysis of that is to say, well, actually, it is simply a question of rationality on weight, which of course is one way of potentially looking at the issue, but it's not the case here. And in this, fairness is a matter for the court. Often things will be simply a matter of weight, a matter of arguing about it, which is not the role of this court or the court below to deal with. But where the material is so critical, where it's not possible to scrutinise what the basis of the conclusion, because the underlying material is not available. It's not that it's simply not produced with it, but it's not produced at all. It's not published elsewhere. It's simply not available to be analysed. Then, in those circumstances, of course, the criticism can be made and was made, essentially made by the examining authority. But we don't know what the evidential basis of this material is. So it shouldn't be given any great significance, or it shouldn't be relied upon.
That's a question of what weight.
Yes, but it's weight.
But of course, the first question is whether it was procedurally unfair to proceed in a situation where the applicant had put in certain evidence but hadn't put in underlying interview. And your first ground of appeal is that the judge did not consider it as a question of procedural fairness for the court. Your first part of your ground one appeared to be that the judge simply reviewed on a Wednesbury rationality basis the decision to allow the material to be part of the process. So firstly, is that right? And secondly, if the judge did review it, and if the judge did decide that it was procedurally fair, what then is your criticism in this court about that decision of the judge, as opposed to re-arguing at the Court of Appeal level that you think it would be preferable to have a decision that said the material was required as a matter of procedural fairness?
And if the court goes to the judgment below, you pick up the point, and submissions are summarised from paragraph 61 to 63. Is where the judge in his conclusions deals with fairness. He deals with it very briefly. He says simply that he's unable to accept there's any breach of the requirements of fairness in the context of the particular case. And then,
but if that's right, that deals with the fairness ground, doesn't it? As opposed to the weight. And if it's not right, and you've got paragraph 66 as well.
And then what's
last sentence?
Yeah, so it's a simple. I don't know, because I just simply putting it shortly. It's a simple dismissal. He says he doesn't think it was unfair, and then in 65 particularly, he deals with the matter of weight. Of course, not how the points put. So the judge is simply saying below he doesn't think it's unfair in circumstances. He can persuade the court that it was unfair because the fact that something's material to the decision makes potentially how that is dealt with very much a matter of fairness, and that goes beyond simply the ability to comment on it, which of course there was, but the ability to deal with it. This is a evidence-based process of examination where the examining authority is asking questions, where participants are able to respond to those in some circumstances as questions of other parties. And where we have a critical part of the evidence base derived from, which leads to the argument that there's a need and is best capable of being met at Manston. Critical part of the evidence base, and that is one which you can't actually get to grips with. No one, whether in fact it's an examining authority or it's my client, no one is able to scrutinise what the reliability of that material is, because they simply don't have it. And that is, in this situation, a matter which simply goes beyond the debate for the decision maker as to what weight to attach to the material, but to a matter of fairness. It's a fundamental.
So you were entitled as fairness to the documentation, the interviews?
That for the material to be dealt with, fairness requires that material is available. Now, that doesn't give a right to require the material from the interested party. The interested party's developer is saying, well, I'm not going to produce it. Then they're not obliged to produce it, but the consequence is that what is then relied upon here in terms of assessment should not have been taken into account, not as a matter of materiality, but as a matter of fairness. And that arises in these unusual circumstances because of the fundamental importance of that report and the evidence base being from the research carried out by the author of the report, this consultant to the applicant, and that material not being available for anybody to deal with.
Were there any powers that existed to enable you to go to the examining authority and say, we need this information? You haven't got the rules there, but I looked at them quickly. There seems to be the opportunity to require further information.
Not to be correct, if anyone has overlooked things, but not in this situation.
In paragraph 65, the judge said there were no provisions that could require the defendant to insist on production of the underlying material. So it seems as if the logic of your submission would be that if the underlying material was not to be produced voluntarily, then not by reason of its relevance / materiality, but by reasons of fairness, then the only course would have been to exclude the azimuth report.
Yes,
that's the consequence of
the
this.
fairness requires it being excluded.
Yes, on ground of fairness.
My Lord, unless I can say anything more on that point, that's everything I was going to say on azimuth.
Just a moment.
My Lords, can I turn then to the second issue, which is the IBA report?
Just a moment while I
Certainly.
keep my note up. Yes.
And I was going to take it along the lines of the way you've structured the grounds B, C and D. So I'll follow those lines and start, therefore, with whether the Rule 19 applies to the redetermination process. And Rule 19, the court finds that in the authority, if we're going to turn the authorities bundle at tab 2, page 7 and 8, and that should be the same electronically as in real life, which is head of procedure after completion of examination. The redetermination process, of course, is after the completion of the examination. Paragraphs 1 and 2 deal with the examining authorities' obligation to report, and then paragraph 3 is the point we are concerned with. if after the completion of the examining authority's examination, the redetermination process still is, the Secretary of State then either A, differs on a matter of fact, or B, takes into consideration any new evidence or new matter of fact, and the IBA report which comes in during the redetermination process is new evidence, and then is for that reason disposed to disagree, then the Secretary of State shall not come to a decision which is at variance with the examining authority's recommendation without notifying all interested parties of the Secretary of State's disagreement with the recommendation, and the reasons for it, and giving them an opportunity of making representations in writing to the Secretary in respect of any new evidence or new matter of fact. So the first point to make in terms of the applicability of Rule 19 to this stage is that the language of Rule 19 falls naturally to apply to the redetermination process, as well as the process prior to the original determination by the Secretary of State. It falls straightforwardly within the words which are there. Secondly, my lords, there's no reason to imply any restriction or limitation into Rule 19 to say it only applies prior to the first determination by the Secretary of State and doesn't apply to a re-determination. The point which the court made, and points my learned friends say, is, well, Rule 19 applies when the public at large and the various participants don't know what is in the examining authority's report. There's a Rule 19.3, that's the argument, and that, well, you won't know that before the first determination because the minister's practice to publish the report with his decision letter. But for redetermination, you would know that. Now, Rule 19.3 is not actually about whether or not those involved know what is in the examining authority's report. It doesn't refer to knowledge of that. What it is about the minister being disposed to disagree with the examining authority's recommendation, either because he differs on a matter of fact or because of new evidence or a new matter of fact which he's relying on. And what the minister is required to do is to tell the participants of his disagreement with the recommendation and the reasons for it. And of course, the way in which paragraph 3 is structured is that the reason for it, and is for that reason disposed, relates back to either disagreeing on a matter of fact or because there's new evidence or there's a new matter of fact. So what the minister is required to do is to say, I'm disposed to disagree with the examining authority's recommendation because either I disagree on their factual findings or there is this new report and I think that's more persuasive, or I may well think that's more persuasive with the other material than what the examining authority is saying. Now, none of that relates to whether or not people know what's in the examining authority's report. Of course, when the minister says, I'm going to disagree, disposed to disagree, you will, if people haven't seen the report, be indicating, of course, which way the examining authority is going on that. But it's not a provision which is concerned with knowledge of the examining authority's report. It's the minister being disposed to disagree with the recommendation. And So that degree of analysis, say the situation would be that the Minister adopted a practice of publishing the examining authority's report in advance of his decision. Rules don't stop him doing that, but that's not what's done. Then, in those circumstances, 19.3 would only kick in if there was new evidence or disagreeing on a matter of fact and disposed to disagree with the examining authority's report for that reason, as opposed to simply disagree because he's weighed up the balance differently.
So well, the essence of the submission is that 20 is supplemental to 19.
Yes, they both operate in the situation we're in here of a redetermination. So 20 operates as redetermination, but 19 does as well. And 20 is the Minister, redetermining, has to say what he particularly wants to hear more about.
We need to break it down a bit more than that, don't we? Because firstly, there's the start of the redetermination process, and there might have been evidence of new evidence or new matters of fact between the quashing or between the initial decision and the start. And the IBA report, of course, doesn't come into that category because that didn't exist at that stage. But you're submitting, I think, that as well as applying at the start of the process, 13B can apply if during the process of redetermination, in one or other of the consultation rounds, new evidence, the IBA material, comes into existence and is submitted to the Minister, and for that reason, here the IBA report, he was disposed to disagree with the recommendation.
Yes, my Lord.
And you're saying that it applies both at the start of the process and in the event that new evidence arises during the process.
Yes, my Lord. And I mean, regulation, so Rule 19 obviously applies, Rule 19.3 applies at any point up to the issue of the decision, and whether that's the first time or the second time. And in a sense, however, that material has come to the Minister's attention, but if it's come to his attention, he's inclined to differ from the recommendation, then he has to consult on that.
But your general point, no doubt, is that if the Minister has to do it again, then it can't possibly be do it again to a lesser standard
Yes,
than do it in the first place.
Yes. So, my Lords, so Rule 19 applies, and of course that was actually, in respect of what's referred to, which we'll come on to a little more in a moment, redetermination corresponds, the view which the Minister himself had taken in his decision. So, if my Lords just pick up from the core bundle, AB 464, which is right at the tail end of the decision, and paragraph 265 in the Secretary of State's decision. And there, in respect of what the Minister's referring to as redetermination correspondence, so that, and we'll come to that a little more in a moment or two, is correspondence that's not put in the course of the 3 consultation stages of redetermination. It's other correspondence which has come in that period. The Minister does seek to apply Rule 19.3 and says, well, there's nothing in that which I need to consult on again. Now, Court took the view that on that point, and it's the bottom of paragraph 72 Mr. Justice Dawes' judgment that the reference in paragraph 265 of the decision to Rule 19 is an error, because the court below took the view that Rule 19 simply didn't apply in those circumstances. The Secretary was right to take the view that it did apply. The Secretary of State's error, which I'll go on to, is that he doesn't deal with it in the context of what's submitted in the consultation process, in this case the IBA report. So the first point, my Lord, is that Rule 19 did apply in the redetermination process. I then need to deal with is how it should have been applied in this case.
Is that, are we moving from B to C?
That's
in the old
B to C,
language?
yes. Thank you. And turn first of all to look at the one authority on the equivalent provision, which was in the planning regime, which is the decision in Gladman. And my lords have that in tab 17 of the authorities bundle, working electronically. The judgment itself starts at page 396.
Well, I've got tabs in the electronic version, so you don't need to worry about that. Thank you.
I'm pleased that the hyperlinks
Simplifies the task.
Yes. And that concerns a similar provision, really a forerunner of Rule 19.3, which is contained in the planning provisions. So dealing with situations of Secretary of State's determination on planning appeals, and this is a refusal of planning permission. So the Secretary of State had recovered jurisdiction, rather leave it to the inspector to decide the minister was going to decide it himself. And the equivalent provision in the planning regime, the court will see at paragraph 19 of the judgment. We also have the text in the authorities bundle, which is Rule 17.5 of the 2000 rules, which itself had appeared in the earlier rules.
The facts are quite important. You skipped over the facts, but here, after the report, he went on to the, one of the issues was how much land did they have for building houses, and the inspector said 3.7 years land. After the report, the minister went on to the local authority's website at a later date and found that, according to the local authority, more land had been brought on stream, and there was somewhere between 3.7 and 5 years land supply, and that was the new evidence or fact that arose. So, and as a result, he thought there would be a 5-year supply.
Yeah. So it's the reflection, amongst other things, that the planning circumstances may change, regardless of what other people put forward. So there is this provision that's been in place in the planning regime for some time, and the way in which, how it's to be applied, is dealt with by Mr. Justice J at paragraph 45 of his judgment, and but first of all, Mr. Justice J sets out submissions by Mr. Kimberlin and Ms. Bewley, and then sets out his conclusion on it, where it begins, in my judgment, Ms. Bewley has misconstrued this clause. And so the significant part of the analysis, and I think my lords, the parties from the skeleton seem to be in agreement on this analysis. We will see is that Mr. Justice J is right to say, if we go just a little over a page, if he considers the new evidence is likely to form the basis, in whole or in part, for the ultimate recommendation reached. The Secretary of State does not have to be satisfied that new evidence would constitute the sole reason for a different recommendation. It merely has to form part of the decision-making process. And that, my lords, is the correct analysis, because my lords will appreciate that very often the new evidence or the new fact is going to relate to an issue which is already in play, where there's already material on it. And if the Secretary of State is disagreeing on the basis of that new material, or is disposed to disagree, it will often be that that is providing additional evidence which leads to the Minister tilting his view in a different way from here the inspector, or in the case we're concerned with the examining authority.
Is Mr. Justice J going a little further than is appropriate in his concluding sentence in paragraph 45? He says that Rule 17.5 applies whenever the Secretary of State has a fixed conclusion that it won't be taken into account or is clearly immaterial. Is there another situation where the Secretary of State has regard to the evidence but reaches the conclusion that it doesn't actually affect the outcome?
Yes, my Lord, perhaps it's best to read Mr. Justice J in that final sentence as not seeking to alter what he said earlier on in the paragraph. He's right to recognise that disposed to disagree is impose a lower threshold, but it doesn't, of course, follow if there is new evidence which is material. So, sort of flipping his point round the other way, it doesn't follow as new evidence that is material that, in this case, 17.5 is triggered. It has to be new evidence which leads that the Minister is disposed to disagree with the recommendation. So it may not alter his view on the recommendation. But
two things, aren't there? One, you're saying it needn't be the sole reason. It could be one of more than one reason. But when the judge below talked about the decision-making process, that isn't actually the word. It's got to be for that reason disposed to disagree. And if, in fact, as my Lord says, the Secretary reads the evidence as well, yes, that is new evidence. Yes, I can see it's been put in. But actually, the reason why I'm disagreeing with the recommendation is X. It's not going to be for this reason. Then he doesn't, does he have to go back and reconsult?
Well, if the new material is part of what leads to it, and that's the reason I make the point, there may well be that new material is on a different issue other than why the Minister disagrees with the recommendation. Maybe on a entirely different.
If it's a completely new thing, they discover there's a rare orchid or an historical site, and he says, hold on, stop, something new here, that's one thing.
Yeah.
But we're not dealing with that.
No. My Lord, what we're, and also, my Lord, we're not dealing with new evidence which may be of interest and importance, but on an issue that's not decisive. What we're dealing with is perhaps the quite common situation where these issues would arise, where it's on an issue which is already live, which is the question of need. Mm-hmm. There is evidence which is put in by, which is already in front of the examining authority on need from the applicant. So contrary to the examining authority's view, the azimuth report. So there is material which is contrary to the examining authority's view, because they've analysed it and they've disagreed with it. There is more material coming in which goes to the question of need. I'm going to go a little bit more into how the IBA points out, particularly, I'm trying to, my Lord, at this point, deal with the question of what's the legal approach to 19.3 in the light of Mr. Justice J's comments here. So it's additional material which sort of goes, I might say, on the pile of the evidence which is against the examining authority's approach, the minister is disposed, I mean, that was ultimately the conclusion he reaches, to disagree with the examining authority's recommendation because of his view on need. And part of what contributes to his view on need is the IBA report. Now, what is often going to be difficult to do, and that's why Mr. Justice Jay is right in his analysis, is going to be to say, well, where you've got this accumulation of evidence, some of it already existing and some of it new on a particular current issue, to say, well, the new material is the sole reason why there's a change. Because quite often, and this is an illustration of that, the new material is pushing in the same direction, trying to back up the material which is there already, and the minister is reaching a conclusion that in this case there is a need, and it's a need which is able, should be met at Manston because of...
Is that enough? What if the minister says, well, yes, that's the view I've reached. That actually is supported, or part of it is supported by IBA. That's not the reason why I disagree. The reason why I disagree with the XA people is that I just disagree with their assessment of the azimuth. So if you're dealing, particularly when it comes in this consultation process, not at the start when you can't perhaps quite predict things, but when something comes in the process, he says, well, yes, I see that, I see it could go on the pie, but it is not for that reason that I disagree with the recommendation. Is he then required by Rule 19.3b to consult on it?
Well, if on the minister's reasoning, ultimately, it actually made no difference, then in those circumstances, the minister wouldn't have to go back on something which doesn't alter.
That's not what Mr. Justice Jay is saying. Certainly not in his last sentence.
Yeah. And my Lord,
making no difference is not what is not the test that he's setting. He's setting something altogether more Spartan as a test.
Well,
His test seems to be that if the minister mentions it without having gone back, that will be unlawful.
No, I think
I mean, I'd say mentions it for any other reason except to say that it's irrelevant.
My Lord, the reasoning of Mr. Justice Jay, this is which I think all the parties rely on, certainly what we rely on, is what he is saying in where we say if it's likely to form the basis in whole or in part.
Yes, it's the in whole or in part, but I mean, in part is such a flexible concept. I mean, if 99 parts I'm relying on azimuth, but I'll throw in one part of IBA. Well, I mean, where do you draw the line? Well, I mean, it seems to be very sensibly said. I don't know whether you agree with it by Justice Jay that this really is all part of the common law duty of fairness, and it's just one instance of it. And that the common law duty of fairness can't be interpreted in that way. It's a more practical approach.
It's clear. I mean, it is a in this case, it is something which is leading to, in any case, it is something that leads to, and that disagreement, bearing in mind that which my Lord says, well, if it's 99% azimuth and 1% IBA, there's no great difficulty in the court or the minister in applying it, saying, well, actually, this particular bit of information is.
Well, I mean, I would have thought there might be a landing point saying that if new material is likely to play a significant part in the decision-making process, then it should be consulted upon. Yeah. But if it isn't playing a significant part, then it isn't.
Yeah, and
I mean, if that's, I'm not sure what objection there could be to that sort of formulation, but you appear to be arguing on the basis of this for something that's more demanding for the decision maker.
My lord, I'm not, and
Well, that's helpful.
Don't suggest that Mr. Justice J was doing that either, because in part clearly it has a notion that is of some significance.
Yes.
To that analysis, a point that's true. But of course, one point we have to have in mind is that we are concerned with a decision-making process which is intended to reach not only the right decision, what the minister thinks is the right decision, but to do so without taking longer than we need to take.
I wonder if part of the problem, the language that you're using and the language that Mr. Justice J is using, switches sometimes from the decision, what was the reason for the disagreement, to the process, what's being taken into account, has it been considered? And at times, Mr. Justice says that merely, the new evidence merely has to form part of the decision-making process. And unless it's clearly immaterial, that's it. But in a situation, particularly in a re-consultation stage, and the information emerges, and you can look at the decision, shouldn't we be focusing on the causative? Was it for that reason, or was that a reason why the disagreement existed? We can test it when you've got the decision. You can look at the decision, and you can look at the new material, and you can say, was that the or a reason for the disagreement? Isn't that better than saying it's part of the decision-making process, it's taken into account, therefore there must be further consultation on it?
Yes, well, it's where we go back to the language of Rule 19 is for that reason disposed. So it's not simply that it's relevant material in the process, but it's something which is a cause, whether in whole or in part.
It has a causative bearing on the change.
Which leads to the change. And I suggest, my lords, that the way we have put it in argument and the way in which Mr. Justice J puts it in argument is all essentially to the same point, that it's that it is whether it's a cause or it's part of the reason, it is a new material of significance which is leading to disagreement, and therefore the minister is required to tell people of that.
Can I ask another question, if you finished on that? I didn't mean to interrupt you. But for this provision to operate, the minister has to be disposed to disagree with a recommendation.
Yes, my lord.
And the way that the judge dealt with this was that he focused on need, because that was obviously the critical issue. But more broadly, I take it that the recommendation is the specific recommendation in this case, 11.3.1 on AB 780, that the SOS should not grant development consent.
Yes.
So it's not triggered if the Secretary of State is disposed to disagree with the assessment of the EXA on some specific issue, unless that issue itself is causally related to the grant or withholding of consent.
Yes, it has to lead to, it's something which may affect not simply a conclusion on an issue, but an issue which either would lead to the order being made or not made, or conceivably an issue which affects the terms in which the order is made. Presumably that's of some importance. Here it is the issue of need goes to whether or not the development consent order is being made, not least because this scheme, like I expect many, if not all, major infrastructure projects, is going to cause a degree of harm, which requires justification.
So if we're dealing with this kind of case, where new material, new evidence emerges in the course of the consultation process, is it acceptable to do one of the following two things? Firstly, is it acceptable to say, well, we've got the decision letter now, and we can ask, by looking at the decision letter, from the way it's expressed, whether the new evidence was a reason for disagreeing with the recommendation, And secondly, if the Secretary of State himself says, as he says in paragraph 265, that he does not consider that any of the new evidence is what causes him to disagree with the recommendation, does that affect the situation so that we're only dealing with a rationality assessment of that? So it's two questions.
Yes. My Lord, in terms of the role, the court is obviously able to look at the decision letter, and the decision letter on the basis it is adequately reasoned. There's no challenge to the reasons, leaving aside the way in which ground the third point comes up. The court is able to understand why the minister reached the conclusion he did. And so the court is then able to apply Regulation 19. Now, the question which, the second part of my Lord's question is, well, in a sense, to what extent should the court leave it to the minister in Regulation 9, in Rule 19.3? And following on from that is what happens if the minister doesn't actually answer the question. This situation where the minister, because we've looked at paragraph 265, doesn't ask the question in respect of the consultation round material, including IBA.
Well, that's the question.
So,
yes.
so the minister's
got to pass the thing, but deal with the general position first. If the Secretary of State says, I don't think there's any new evidence that's come out in this redetermination process which is the reason for me disagreeing, is it a rationality or is it the Osborne fairness test for us?
My Lord, it's a fairness test in terms of the court being able to apply Rule 19.3, but it's doing so. This may be why practices are making difference either way. It's doing so in a situation where we know, on the basis we have an adequately reasoned decision letter, why the minister reached the conclusion he did. And so the court is able to understand, if the reasons are adequate, what the role of the new evidence was.
There are two questions really. One is the general letter, leaving aside 265, and you've said very fairly that you can look at the decision letter to see if the new evidence was a causative factor in the disagreement with the recommendation. We're on a much narrower point now, which is 265. We've got submissions to make about whether or not that paragraph was in effect addressed to the IBA report. But in terms of if the Secretary of State in the particular paragraph here, 265, does look at the new evidence, says, well, actually, that's not what caused me to disagree, it's something else. Is it a rationality, or the Osborne, the court decides for itself whether it's the correct conclusion?
My Lord, it's the court. I think it's the court being able to decide for itself, because it's an application of the rule in a situation where the evidence is in front of the court, because the court knows what the minister's reasons were, because they've given them awfully. I would say that also it's one of those situations which perhaps doesn't, however, whatever approach is applied, leads to the same result, because if it was looked at in rationality terms, it's looked at in rationality terms where we know what the minister's reasoning was. So we know from the minister's reasoning to what extent that new evidence was taken into account, and what influence, judging from the reasoning, it may have had on the decision. And if we're looking at, well, was this new evidence a reason for the disagreement? Looking at the decision letter, looking at an adequately reasoned decision letter, there should only be one answer. It was or it wasn't. So even if it's one of the situations where even if a rationality test was being applied, the court will be able to conclude, well, either the minister could have reached that conclusion or he couldn't have reached that conclusion. So, it's one of those situations where ultimately the question in front of the court is it's a binary one rather than where there is actually a large degree of judgment open to the minister, which the court should be reluctant to get involved in. I hope that covers my Lord. So, my Lord, what I've dealt with is so it's the legal approach to 19.3, what the trigger is in those terms. I want to we can put Gladman and the authorities bundle away, and what I want to do is then turn to how the IBA, going through the exercise since we just discussed, how the IBA report is dealt with in precision, and to therefore lead to the conclusion that it was a reason or part of why the minister disagreed with the recommendation of his examining
Right, is that D?
authority.
Are we on D now?
My notice still put it as C, but I think it may still be D. It's the this term.
Well, I'm just going on your skeleton argument, which appears to have dealt with the Gladman case under B, and moving on to
from
the IB report, procedural fairness, paragraph 52. Is that what you were pursuing?
And it's also in my skeleton 57 and 58.
Yes, these are under ground 1D, the IBA report procedural fairness. I'm only just wanting to know where we are in the argument.
So we're still on IBA. So it's at 57 and 58 of the skeleton, which is a ground C.
Right, I can see where I've gone wrong. Thank you.
But it shades. So it really is. Yes, it is still.
Okay.
It is still C.
Thank you.
So it's.
Skeleton paragraph 57 is roughly where you are.
So my Lord, that is some of the.
Yes, my apologies.
57 of my skeleton, and I want to pick up some additional references to there. The IBA report is expressly referred to in 4 paragraphs in the Secretary of State's decision. So, first of all, it comes under the section, which, just for context, starts at page 421 of the core bundle, which is air freight demand and forecast. And that's a section that starts at paragraph 79. And as the court will have seen, the initial analysis of that is discussion of azimuth.
But this is a discussion of the different people's assessment of air freight demand and forecast, isn't it?
Yeah.
This is what this section is about. We're not on to his conclusions. He's reviewing what other people have said about air demand and forecast.
And so paragraph 84, which is at page 423, the minister is describing what the IBA report is dealing with, and that includes both the sort of demand for air cargo, but also a particular point which is being made in favour of the Manston scheme, which is the demand for specific air freight flights, because the court will have picked up that an awful lot of cargo goes belly hold. So in passenger airlines which are flying routes that primarily carry passengers, and then some freight is carried by dedicated cargo aircraft. And Manston is, as a freight operations intended to be focusing on those dedicated cargoes. So
The key point you're saying is it'll be between 13,000 and 35,000 extra air freight flights, not belly hold airfield flights, and there's only 6,000 coming, Stan said. So that leads these people to conclude it's between 7,000 and 29,000 extra.
Yes, and that's and the IBA report, the paragraph 84 goes on to say, well, essentially there's a shortage of air freight, and the dedicated air freight flights into the UK, because it looks to us as if people are flying freight which is aimed, it's going to the UK, flying it into European airports, and then bringing it over by road through the Channel Tunnel, Paris, what have you. So paragraph 84 is dealing with the IBA report.
Just for completeness, paragraph 85 appears to be dealing with the same point, not so much with figures, and it's the last sentence. Secretary of State notes that a number of interested parties submitted other news and industry articles and reports talking about a move effectively to aircraft that don't include aircraft capable of putting it in the hold.
Yes, there's a few points there derived from essentially sort of news reports rather than anything more.
Well, news and industry articles and reports is the phrase it's used there.
The COVID point was that, as the court will appreciate, an awful lot of passenger transport was shut down.
Yes.
With the result that more freight was being moved by dedicated flights. So the Secretary of State then deals with his conclusion over the page on demand and forecast, which of course we have to read the decision letter as a whole and the reasoning as a whole. He's drawing on what he's looked at already, which includes IBA. And then he also, from page 426...
Well, sorry, don't we really... I mean, in fairness, we can't just island hop about it, because he's reviewed what people have said, and his conclusion on this part, which is not the recommendation, is in 89 to 94. And where in 89 to 94 do you say that the Secretary's conclusions on that part were based on IBA?
Well, he makes no specific reference to IBA in those paragraphs. What he does do is conclude that there is the need. Paragraph 91, where he expresses satisfaction with the outlook report demonstrates there's demand for the air freight capacity that the development seeks to provide.
And the reason for that is not the new evidence, that's the Azimuth report, is it?
He doesn't refer specifically to IBA within that. Paragraph 92 deals with other reports in e-commerce, which I will
That appear to
come
be
to
reference back to paragraph 85.
e-commerce in due course in respect of the IBA report. But what the Minister is doing, he's not, in paragraph 84, anything that follows, he doesn't say the IBA report is unimportant. What he does say at the end of paragraph 84, if we go back to that, my Lord, is that having a reference to some evidence on increased road freight, Secretary said that this data demonstrates a sustained growth in air freight demand. no point is the Secretary of State differing from what he's summarising the IBA report as saying at 84, or saying that it's not a contributor to the reason he comes to. Well, my Lord's right, of course, to say that with a decision letter you can't hop from one bit to another and leave out other parts of that. But of course, my Lord, that also goes in this context to where an overall conclusion is being reached, and the minister has commented about or put down about disagreement some of the evidence, and that evidence is pointing towards the conclusion that's reached. Even when he reaches that conclusion, it doesn't follow that, well, if he doesn't mention that report when he reaches his conclusion, it was obviously not of importance, or it was left out of the account when he reaches that conclusion. It is, of course, a matter of looking at the reasoning as a whole to understand why he does what he does. And he is reporting, at 84 in some detail, he's reporting favourably what IBA is telling him. And then he also comes to IBA in the section that starts at page 426, which is his conclusions on capacity. We'll deal with this separately on ground, the third issue, but just on this topic, my Lords, paragraph 100, which is at page 427, the Minister notes that the IBA report also contends that reliance should not be made on capacity and Heathrow, and then the IBA forecasts a return to pre-pandemic belly hold freight levels in Heathrow. So the IBA IBA is relied upon in terms of capacity as a steer away from the line of belly hold at Heathrow. And then if we go to page 429 on e-commerce, and the argument essentially on e-commerce is that people are shopping online more, therefore more goods are being sent as parcels, and in some cases sent quite a distance, so that would essentially increase the need for air freight. And paragraph 109 second line refers to the data from IBA setting out demand from e-commerce. And then paragraph 110 is reference to the IBA report, which suggests that commerce requires full freighters and not belly hold freight. And that, of course, is a large part of the case for the development of Manston, which is that that the need, it is said, is for dedicated cargo aircraft movements rather than relying on belly hold. So existing passenger flights, and the points being suggested, well, it's tied into what the passenger schedules are, and how much you can accommodate on a particular aircraft at a particular time. So the IVA report is going to say, rather than, if you do need more capacity, passenger flights in and out of Heathrow are not going to be what's needed. What's needed are dedicated flights, which is what Manston is about. So those are the direct references to the IVA report. And those are, my Lord's, important elements in the Secretary of State's analysis. And it is a reason, or part of reason for the Secretary of State's disagreement with the examining authority's recommendation that the IVA report is there. The IVA report is not something which simply happens in front of him. It's not something which he mentions as simply he has. He directly draws upon the IVA report at 4 points, and it informs his reasoning on both the need for air freight and the type of air freight, and on capacity.
For completeness, do we need to look at 125 and 129 as well? Because they also give us the overall conclusion on need,
Yes.
having regard to the various factors that you've just referred to. And we're building up to the reasons for the disagreement. And there he sets out his overall conclusion on need. And is there anything in there about the IVA report?
There's no direct reference to IVA in those paragraphs. What he does find is that there is in paragraph 125, the middle of that paragraph, is referring to examining authority consideration of various demand forecasts, middle of the examination application, satisfied the estimate report demonstrate there will be demand for the capacity that the development will release.
Now, is there a place, so far we're looking at disagreements with conclusions on an issue. Is there anything in the report that you ought to look at to see what the basis of the disagreement with the recommendation exists?
So look at...
So far we're looking at disagreements
Yeah.
with conclusions on a particular issue. You'll remember my Lord's question
Yeah.
that we're looking at is the disagreement with the recommendation. And I'm wondering if there's anything else in the report that I need to be looking at when assessing the reasons for the disagreement with the recommendation as opposed to the conclusion in the issue.
Now, when we come to the Secretary of State's conclusion on the planning balance, which we find at page 450.
450, thanks.
Paragraph 199. This is after he set out at 196 various harms from the scheme. But at 199 he does the planning balance between harms and benefits, and then says in the starting the second line, for the reasons given in the need section above, the Secretary disagrees with the examining authority's conclusion on need and considers there is a clear case of need for development. therefore concludes that significant economic and social economic benefits would flow from the development. And this, and gives this slight typo there that should be given substantial weight in the planning balance. So what he does in 201, having weighed the expected benefits against potential negative impacts, he is of the view, last line, the potential negative impacts do not outweigh the projected benefits. So
the conclusion on need is, at least you say, a reason for the disagreement, and you say the conclusion on need was influenced by a consideration in part of the IBA.
Well,
sorry, can I just make a note of that?
So, my lord, the conclusion on need is decisive because the benefits which the Secretary considers flows.
Hold on, I need to make a note, and I've now lost
Sorry,
the
my
note.
lord.
The conclusion on need is a reason for the disagreement, and part of the analysis on need includes reference to the IBA report, and that's sufficient for Rule 19.3. Let me just make a note, just pause for a moment, please. Thank you very much. Sorry to be so slow.
So, my lord, what I was going to say was that the Secretary's conclusion on need is decisive because the benefits which he identifies from the scheme arise from there being a need which is being satisfied.
Yeah.
And so, if he'd agreed with the examining authority on need, the scheme would have been refused.
Yeah.
It is that important on that issue. My lord, that does mean that not 19.3 was triggered. It also then takes us to, well, what actually to D and what actually happened.
Are you going to deal with 265 in this context?
Yeah. So what I'll do on 265 is come back to that when I've taken the court through the various letters referring to consultation.
Yes.
Because it then becomes a bit clearer what's actually been referred to in 265. But in the point of D, it may be helpful at this point to turn up my skeleton at page 15. And just a question what the test is for fairness, because I say that in addition to Rule 19.3 triggering the requirement to consult on the IBA report, fairness required that. And just from the skeleton, I want to just briefly deal with the test for fairness. It is it is simply a question as to whether the process was so fair as to be unlawful. And I've set out there the way in which the dicta about clearly and radically wrong, which Mr. Justice Sullivan had used in Greenpeace case, how that's then dealt with by the court since, by reference to the Bloomsbury decision of this court, and to just to sort of pick up in paragraph 62B of my skeleton, what Lord Justice Sullivan, as he then became, had referred to, referring back to what he said in Greenpeace, that clearly and radically wrong wasn't seeking to put forward a different test. So it is so unfair as to be unlawful is the appropriate approach, and I've set out the authorities there. And that, of course, relates to the significance of the new material and the need to deal with it. And I sense I've dealt with that point in having gone through the Secretary of State's decision letter as to why I say that's significant, you be dealt with. What I now want to deal with, my lords, is the final part of this ground 2 issue, which is, well, what was there the opportunity given to make representations on the IBA report? And what I want to do then is to take the court to where the Secretary of State is seeking representations of what he's saying about it. That will help explain, I hope, what is going on with the redetermination, reference to redetermination correspondence. So, my lords, if we go, please, in the supplementary bundle to the statement of matters, which in the supplementary bundle is hard copy is page A, so it's page 791, and I think will be page 249 electronically.
253.
My lord, I'm grateful. And so that's the 11th of June 2021, which the Minister starts the redetermination process out of quashing. He sets out in paragraph 2 the matters under Rule 20, and he also, so he's asking for representations on those 4 matters. He's also in paragraphs 4, 5 and 6 seeking information from particular participants on particular matters.
At this stage, the IBA report didn't exist, so there's no problem with this letter not referring to it and just focusing on 2020. What happens afterwards?
Yes, my lord, what I'm seeking to do is to deal with the question, well, essentially the question, to what extent, if at all, were people basically told, well, look, even if we're not asked for comments, can you just put them in? Yeah. And so I will just take my lord through the 4 bits of correspondence which go to that point as to what was going on. So paragraph 7 emboldened the deadline for any response is 9th of July 2021. So the Minister's asked questions, he wants a reply by a particular point. He then refers in paragraph 9 to the independent assessor, paragraph 10 saying that there will be an opportunity to comment on the assessor's report, and then the representations received. So he's saying there will be a further consultation following this round. 11, he says, well, anything we had before the previous decision ought to be sort of reference if you're referring back to that. Then at 12, he says that anything that came in between the date of the previous decision, July 2020, and the state of matters, whether that's before or after the quashing of the first decision, not been published and will not be taken into account, as such will not be taken into account as part of the redetermination process. And that if participants wish those documents to be considered, then they should resubmit the correspondence and to do it as treated as a formal representation in the state of matters. So what the Minister is actually saying though, so things I didn't ask for, which I've had since the previous decision, I'm not going to take into account, but if you do want me to take them into account, you need to put them in again as part of this consultation process. So it's not encouraging free-for-all at that point. My Lord, we then have the next in the sequence is the document I handed out this morning, which is the 30th of July 2021 letter. And that is a letter about the publication of the responses to the statement of matters. So that's after the round one consultation. And going over the page, paragraph 5 says, well, those have been, representations have been published. Give an opportunity to consider those before the second round of consultation commences. And then paragraph 6, if you wish those to be treated as a formal consultation response, they should be submitted. What you may say on those should be submitted when the second round of consultation commences. And then paragraph 7 says that correspondence received between the close of the first and the commencement of the second round of consultation will be treated as redetermination correspondence and will be published as such at the end of the redetermination process. Now, my Lords, that's not explained there, nor indeed in any government guidance as to what the Minister means, or more particularly how that will be dealt with, other than it being published at the end of the process. What paragraph 6 is doing is saying, is directing people really to be making their comments during the second consultation round. Because that's what the July letter tells us. We then have the consultation, second consultation started 21st of October. That is at bundle page 794. It's straight on from the June 21 letter. And paragraph 3 deals with the enclosing the aviation assessor's draft report, and invites, paragraph 4 invites representations on that. Paragraph 6 invites submissions on what people have said at round 1. And then paragraph 7 is invite 7 8 and 9 are inviting specific comments on particular matters. Paragraph 10, under the heading deadline for responses, sets a deadline for responses in 19th of November. And then paragraph 13 refers to correspondence received between after the first round of consultation. At that point, status will be treated redetermination correspondence will be published as such at the end of the redetermination process. If interested parties who have submitted that wish it to be treated as a formal consultation response, they should resubmit within the second consultation round. So it's encouraging people to, if they have put something in that gap between the consultations, to actually say, well, put it in again, but in the consultation round. And then the final piece of correspondence we have on that is the third consultation document, which is the 11th of March. That is bundle 827. And that, I think, will be page 286 PDF.
There's 229. I've got it.
I should have noted in advance. Testing my length of arithmetic, not entirely successful.
Right.
I apologise.
There's a perfectly reasonable index which actually takes me down.
I always noted the hyperlinks. So that's 11th of March 2022, and that's the third consultation round. The Secretary of State is summarising what's happened so far. So paragraph 2 refers to central matters. Paragraph 3 refers to the aviation assessor's draft report and the opportunity that was given to the interested party to submit comments on the responses received on round 1. Then the Secretary of State, paragraphs 4 to 7, sets out specific requests, all of which are of the applicant on particular matters. Paragraph 8 sets out a deadline for responses, and paragraph 11, well, similar to the paragraph I just looked at previously, refers to redetermination correspondence, and saying the interested party who have submitted redetermination correspondence with any comments they wish the Secretary of State to treat as a formal consultation response should resubmit again within the consultation 3 deadline. So, firstly, the Minister does not invite representations on the IBA report, or indeed on any other stage 2 representations, but it doesn't invite representations on the IBA report. And he does that in the course of correspondence, which is referring to a specific opportunity to comment on the stage 1 consultation response as it's given at stage 2, and where correspondence which is going in between those consultation stages, the Minister is encouraging participants to put in the formal consultation process and say they're to be treated as a formal consultation response. And all he says about the remainder of that correspondence is either before the statement of matters, if it went in before the statement of matters, I'm not going to take it into account unless you put it in the course of the consultation stage. And everything else, he says, well, I'll publish it at the end. What the Minister is not doing is inviting representations. And this is in a process where if he is going to get representations, he does need to invite this. As the court may be aware, the examination process is one which relies very much on stages of the examiners setting questions which they want comments on, then opportunity usually for comments on other people's replies and so on. But it is a formalised and structured process, and it needs to be to enable the issues to be dealt with in a manner which can be managed and understood, and people know what they're responding to, and the decision maker is able to go through that process.
Stage 1 was the general matters.
Yeah.
Stage 2 was the specific draft report of the assessor. And stage 3 was specific points that aren't of material here. And the problem that's occurred is something was said at stage 2, the consultation about the draft report, which you say has wider significance, and therefore there should have been a specific invitation in response to that document of wider significance.
And my lord, it's a process which our participant wouldn't have understood from this correspondence, or wouldn't have understood from the process more generally, of what I've described in the skeleton, as a free-for-all where people would be able to sort of simply put in representations about any of the matters at any time on the basis that the decision maker would be taking them into account. That's not a process which either the examination or at this stage would be remotely manageable. And what the Secretary of State was seeking to do, we've seen in correspondence, say, well, I want to hear about particular things. I'll give you perhaps a general opportunity of viewpoints, but within a particular period, this is a deadline. A reader of that would not have understood, as now seems to be the Secretary of State's case, that, oh, well, I weren't given an opportunity to comment. Nobody said we could comment on the IBA report, but we should have realised we could have put something.
Well, could you just, for my benefit, go to the IBA report at 263 and electronic bundle, supplementary bundle. It's hard to see what the number is. AB 801 in the paper copy, dated the 15th of November. Could you just insert this into the chronology? That's the date of the report, which shortly before the deadline.
It's shortly, my lord. It's shortly before the deadline.
Yes, for the second round of consultation.
The second round.
And what then physically happens to this, or digitally happens to this document?
There is a particular page on the Planning Inspectorate website.
Yes.
For this particular scheme.
Yes.
And documents submitted are then published on that. The documents,
right, so that was published along with a load of other stuff.
Along with it was published along with other material. It was published after the round 2 consultation had concluded. I think it was probably actually submitted very much close to the end of it.
It was published on the 12th of January.
Well, that's why it's in the index. It says report 12th of January. Right, so it's submitted 15th of November, finds its way into the public domain on the 12th of January. Is that the right?
So, my lord, there's no opportunity. Nobody could have seen it within the round 2 deadline.
On that, I'm just looking at the chronology at AB 20, so you know where I am. So I've got 21st of October, 4 from the bottom, is the second consultation opens. 15th of the 11th, the report was submitted, the IBA report. 19th of November, we know from the letters you showed us, was supposed to be the end. But I've also got, on this chronology, December the 3rd, 2021, the claimant submitting further objections. So she appears to have submitted further objections after the close of the process, or not, just so that I understand what's happened.
I think what has happened is that further time was asked for that submission to go in.
Right.
So it was put in as part of the second consultation. If I'm misunderstood anything, I'll be correct.
Right.
I think it's
So it was extended for her or generally?
But for her, the request was made for additional time for work.
Right. And then that leads to the next question. You referred to they should have invited submissions on the IBA report put in as part of the second round consultation. The question I was going to ask, were they also required to invite representations on the other documents put in as the second round, including the claimant's documents now, which we understand was put in at the second stage by an extended timescale? Did that have to be consulted on?
It didn't under Rule 19.
No, under common fairness. No, we're not on Rule 19.
it's treated as a matter of significance. It wasn't wasn't something which was in the end of importance in the sense the Secretary of State didn't.
So if you're dealing with common procedural fairness, and you're saying documents produced during the course of the consultation process, there is case law on this. When must you enable further responses on documents that have emerged in the second consultation document in the process? And why some and not others? Some and not others.
It becomes a matter of whether the material is significant. That must be the approach, because otherwise there can be a danger of a sort of a never-ending round of comments.
It's not all second consultation documents and responses, only those which are significant in whose view?
Yes, simply as a matter of principle, there may be a number of documents which are
Is the real complaint here about the letter of the 11th of March, in that although the IBA report was in the public domain and to be found by anybody who had an interest in this topic, you say that that letter ought to have specifically asked for comment upon the IBA report?
Yes.
Is that what the complaint is? Is that what the complaint is?
Yes, because it's a structured, it's a structured process. Would understand that. The minister, in the third consultation round, simply said, "Well, I want to hear from the applicant on these particular points." He wasn't doing what in fact he had done in the second round, of just saying, well, I would like to hear anything people have got to say about what was said at the previous round.
But he doesn't have to do that generally, I thought you said. He doesn't have to do that for the York report or for anything else. It's those things which, in somebody's opinion, and you'll tell me who in a moment, in somebody's opinion is significant. It seems to be the test.
Well, my lord, that must follow, because otherwise it becomes a danger of simply having endless rounds of consultation until everybody is so exhausted that they say nothing more.
So on common law fairness, who decides whether it was so significant that it should have been the subject of consultation? Is that for the court or for the Secretary of State? Or?
I mean, ultimately, once the decision's been made, any questions of fairness are matters to be decided by the court.
So it's not that there should have been a process for all consultation documents to be commented on. It was the failure to require specific comments on this particular IBA document because objectively analysed by the court, it would be unfair not to do so given significance.
Yes.
And am I right to think that your point doesn't really necessarily get tied to the 11th of March 2022?
No.
It's tied to the point at which the Secretary of State has reached the state of mind described in paragraph 19.3, disposed to disagree.
Yes, in terms...
Whenever that was, we don't know.
Well,
sometime before August.
Yeah. Well, certainly in terms of applying 93, and also because in judging fairness, whether something's of significance that should have been consulted on, it does matter how it's then dealt with. So if it had occurred to the Secretary of State, well, actually, this material which we had in round 2, in this case the IBA report, is important, and either by 19.3 or because of simply a matter of fairness, people ought to have a chance to deal with it.
So it wasn't to do with the letter of the 19th of March was addressed only to the applicant. It didn't seek any further comment from anybody else. What you're suggesting is that there ought, at some point in time, have been an equivalent letter which was addressed to everybody else, which referred to the IBA report,
Yes.
a new
Yeah.
chapter.
Yeah.
That's what was lacking in your submission.
Yes, my lord. And without that, it couldn't have been expected that people would have put in representations. As the court will have seen, one person did put in a representation referring to the IBA report, but that wasn't the claimant who doesn't answer the problem. It wasn't invited. But unless I can say anything more, that's the IBA report.
Well, there's only one point that I wanted to close off, which was to do with what you say was an error by the judge, paragraph 76, in referring to the test for in these circumstances. So the Greenpeace quote, paragraph 75 and 76. I can't find reference in the submissions that were made to the judge that refer to either Greenpeace or Bloomsbury.
No.
So is that the judge doing his best in the absence of any submissions made about this?
My lord, I suspect it is, because just remind ourselves of lunch and the drama learned friends will help if otherwise. I don't recall that anybody said anything particularly new on the context of what the approach is in fairness.
Well, if complaint is being made about what the judge has said, and you say there's an authority, Bloomsbury, which would have put things a bit differently, it doesn't seem to me at the moment, at least, as if the judge was given any help with this.
No, my lord, we will check over lunch.
Thank you.
I'm sure Bloomsbury wasn't in front of him. Don't recall. Greenpeace was.
Sorry?
Greenpeace is cited.
Greenpeace is cited.
Greenpeace is the case that he...
No, I know. But
that's all. Yeah.
What I was doing is I was doing my best with the skeleton arguments which do appear in the bundle to see where this came from, and to see whether the judge was either given an out-of-date authority, or if it is, or whether he wasn't given anything.
My lord, I'll check. I don't recall that we went into sort of the question of what the legal test was on fairness.
Right. Well, what? I mean, you've made this point, but what, if anything, turns upon the difference between these formulations clearly and radically wrong, or so unfair as to be unlawful? I'm wondering whether that's something.
In both cases, it's the court saying actually this process has gone wrong in a way.
Well, I know, but I just want to, before passing on from this part of the case, know whether you seek to make any progress with your appeal on the basis that the judge might have been said to have quoted an authority which has been later considered by this court, or whether it all comes to the same difference.
My lord, I'm happy to deal with it on the basis it all comes to the same.
Well, that's really what I wanted to know, was because when we're not marking an exam here, we're just trying to see what matters.
Really, as actually the authorities analysing Bloomsbury are saying, Lord Justice Sullivan is really seeking to say that it's all the same, and the courts, of course, are careful, whilst we will cite authority, careful not to get hung up on a particular expression used by a particular judge, when we know what we're trying to deal with.
Thank
I was a bit puzzled by the selection of the authorities and the things that weren't there, as well as the things that are there. There's lots of very interesting first instance authorities, but it's now emerged in the course of discussion and analysis that the key criticism here is not that all second round consultation documents had to be consulted on, but one had to, because it was significant, and you seem to accept that's the test. There are three cases, one a strong divisional court case with Lord Justice Elias and Mr. Justice Beats and another judge I've forgotten, all saying that it would have been helpful the court to have had those three, but you don't object to us relying on those three, given that they seem to be saying what you say.
No, my lord, our case on this is the IBA report.
Because it is so significant that common law fairness required unusually a response made in consultation to be reconsulted upon. And there's three cases saying it has to be significant, and there are various expressions of it. But you haven't referred to those, but you've no objection to us taking that into
my lord. And this has always been a case, particularly it was also related to Rule 19.3, where it is very clear. Our complaint is the IBA report wasn't consulted on, not putting a general. Well, there should have been a further round consultation. Everything was just set round two, because quite rightly, the court is concerned about, and what the effective process is concerned about, is that people are able to deal with what's important, rather than just going round and round in circles debating things that aren't important. So, my lord, that's why we deal with the IBA report. My lord, if that's everything on ground two, can I turn then to final ground three, which is the question of capacity at the issue in front of the minister is future capacity at other airports. So if there is a need for further freight capacity, can that be met elsewhere? And the error in this case turns on the advice which the minister was given and the draft decision and the documents in front of him. And the minister was, I'll take my lords to the documents in a moment, wrongly advised that he could not take into account future capacity coming forward at other airports, which was a point which the examining authority itself had relied upon. And the court will be aware that in terms of material considerations or relevant considerations, there are three factors. There's the material considerations which the decision maker is obliged to take into account, either because statute or policy says that it has to be considered, or that it is obviously material. In those situations, the minister, the decision maker, falls into legal error if he doesn't take into account. Then there's a category of considerations which are capable of being taken into account. The decision maker can choose to take them into account. If the minister chooses not to take them into account, then there can be no complaint about that. And then the third category are matters which are not material, which the decision maker falls into legal error if he does take them into account. Now, if a decision maker is advised that he cannot take something into account, so something is immaterial, but the correct position is it is capable of being taken into account, then that advice is legally erroneous, and if the minister follows that advice, the minister is then making an unlawful decision, provided, of course, that advice then affects the point is of significance to the decision. But if the minister, so the decision maker is advised wrongly that something is immaterial, they can't take into account, that's a legal error. And I deal with in the skeleton two decisions of this court in the related context of reports by local authority officers to their committees, where the advice was that something was not a material consideration. and that advice is legally defective.
Is paragraph 87?
It is references to holder and
Yes, quickly.
to Wicklow Parish Council.
Yes.
And those are yes, I was right. Paragraph 87, I suppose.
Thank you.
We do need to be careful how the word material is used, because it's sometimes used in different ways. It can be used to mean not legally permissible to have regard to, and not material, not because you couldn't have regard to it, but because there's some factor that means it doesn't really bite on what's happening. And the question is really what was being said in these documents, I think.
So my lord's right that the, of course, in this case, the minister's officials can say to him, well, there is this matter, but we don't think this is something you should take into account because it's so speculative or it doesn't bear on the main issues or whatever. So that's the proper role of officials to advise in the way that the court would be familiar with the role of a council's officers advising councillors as to what view to take on a particular matter. But then the difference, as my lords identified, is between that advice as to really what view to take on the merits of something, is this actually important or not, and advice that says, well, you can't consider.
The minister says, I'd really, really like to look at this. And they say, no, Minister. So Humphrey says no.
Yeah. Right.
So to get into category 3, it's you, the decision maker, are not allowed to take account of this factor. Right, so that's the test. And you're now going to deal with, no doubt, how it applies to what actually happened here.
Yes, so there are 5 references. I want to...
But I'm so sorry. So understand, when we're talking about not material, actually we're talking about not allowed.
Yes, my lord. Yeah. And so, if we go, please, in the
5 references.
one, if we go in the supplementary bundle to the private office cover sheet,
Yes,
which is at bundle page 890.
352.
And so this is the material which is coming from the department to the ministers.
Would you mind just giving us the 5 paragraph references before we go to them individually?
Right. My lord, the references are the private office cover sheet, which is at the particular reference is at bundle page 891, paragraph 5. Paragraph
5, yes.
Then the ministerial submission, which is bundle 893, paragraph 5.
Yes.
And then in the draft decision letter, bundle 926, paragraph 97. And then on 927, paragraph 101, and also again on 927, paragraph 102.
Thank you very much.
So, my lords,
now we can have a look.
if we start first with the private office cover sheet, paragraph 5, the explanation is given but having reference to the aviation assessor. There are, 4th line, there are a number of areas where we disagreed with the assessor's conclusions. And then the final sentence of that paragraph, we, as set out in the decision letter, we think the approach taken by the XA and the IAA has resulted in their taking into account matters not relevant to the decision, giving insufficient consideration weight to various relevant matters, and misapplying aviation policy. So they're not setting out there what those particular points are, but they are distinguishing between their reasons of disagreement, matters not relevant to the decision, and then insufficient consideration and weight. Then if we turn to the second
That
document...
doesn't tell you much at all. It doesn't tell the minister, why is it not relevant? Can I not look at it? Or is there some reason why on the facts it isn't relevant? That in itself doesn't tell you much at all, does it? Or tells you what it's about.
Well, it's saying what they're identifying are they are saying that one of their reasons of disagreement, what it is, comes through later on.
Yes.
Is things which
Let's look at it all together.
which are not relevant, and distinguishing that from questions of weight, what importance it attaches. So if we go next to the referred to as the ministerial submission, it's the consideration by Carl McCartney, who's the minister,
Yes.
redetermination of the Manston Airport planning application. And then in the bottom of that first page, paragraph 5, number of areas where we disagree with the examining authority and the assessor. And I want to just pick up on not only what's being disagreed with, but since why it's being disagreed with. So the first point on resilience is consideration and weight has now been given to the capacity it would deliver. So there they're saying, well, we disagree with the XA in terms of the weight which they're attaching to those matters. Aviation policy is a disagreement on the approach and policy. And then capacity, that they took into account capacity of other airports that could be made available through there in the future. Such capacity is not material to this decision, as there is no certain such capacity will come forward in future. And then the next point is demand forecasting. Proper weight has now been given to, in this case, the azimuth report. And there, what the advice the minister is doing is distinguishing situations where the official advice is, well, we give more weight to what the applicant is saying rather than the conclusion the examining authority reached on that. A matter of advising on the merits, which of course they're entitled to do. And what is said about future capacity, which is, it is not material. And my lords, what is said there and looked at in that context, what is being said is, you can't consider it. That's what not material means in this particular case. And the comments around it, which are different, are supportive of that understanding which the minister would have had. I can turn then, my lords, to the draft decision itself and the three references within that. So if we go first, please, to page 926. And this is in the section, the Secretary's conclusion on capacity. Paragraph 97 tells us that from the third line onwards, that in that sentence, or fifth line, he's only able to attach very little weight to capacity through applications that have yet to come forward. So what that is saying, I'll pull the whole point together in due course. That point is saying you can consider it, but there should be very little weight attached to it because of the uncertainty. Then paragraph 101. The last sentence, which is as with aspirational plans for expansion, decision to increase capacity through general permitted development is a commercial decision. The Secretary is unable to take into account capacity. That points toward not being able to take that into account. And then the final reference is 102. Looking at spare capacity and then saying, well, that appears to be in the context of future plans of potential growth. As set out above, such capacity is not material to the Secretary of State's decision on this application. So 102 is not saying, well, it's uncertain, so I'll give very little weight to it, but is saying it's not material. That is not taken into account. Now, the question, although those five references, the one at 97 refers to very little weight, 102 and 101, 102 is not material, 101 is you unable to take into account. The ministerial submission is not material, and the cover says we have a reason, right, a reason to disagree. One is not material, another is, on other things, is weight. That needs to be looked at as a whole to understand what was being said to the minister. And here, of those five references, 4 of those are toward, we are saying, we're advising the minister this is not material. Not that we don't think you should attach weight to it, or we don't think it's very important. So the advice is that matter of future capacity at other airports is not material. The learned judge's conclusion was that the material in front of the minister was not advising him that it was not material. And paragraph 91 of his judgment, he says, read as a whole, the recommendation was that the potential for airport capacity expansion elsewhere was something which very little weight could be attached and wasn't obviously material. My Lord, court below and this court has the documents. The learned judge was wrong to attach that interpretation to it. We're all, of course, familiar with the need to look at a document which is giving advice as a whole to understand what it is it's saying, and bearing in mind that there may be something which is poorly drafted, and the court is alert to claimants picking on the one badly drafted bit when the rest of the document is saying something which is perfectly lawful and readable. Courts who understood it in the sense of the rest of it. In this case, 4 of the 5 references which bear on this topic are telling the minister it's not material. One of them is pointing the other way to very little weight, but the way in which the minister or another reader of the document would have dealt with it would be understand that the advice is being given, that is not material, that you cannot consider it. And my Lord's that advice was wrong, because clearly whether any capacity in the future could be met elsewhere in the future is capable of being material. Let's take a view as to whether it can be and what weight to attach to it. But it is something which the minister was entitled to take into account and is wrongly advised not to. My Lord, the final point which follows from it is that when the decision is produced, those parts of the decision letter have been rewritten, and what I say first of all is that actually in a sense acknowledges but what was in the draft wasn't correct, but also it's then not corrected. So if we go to the published decision, so in the core document, bundle 426, paragraph 97 has been written to say, in the fifth line, he's not able to attach weight to the applications of the optimum forward, rather than very little, not able to attach weight. And then,
Sorry, just pause a moment.
then in paragraph 100,
That's in comparison to
that's in comparison to
able to attach very little weight.
very, very little weight.
Right.
And then the more significant change, we have 101, the part we refer to as unchanged. 102,
Just pause.
paragraph 102, we have, rather than such capacity is not material.
Sorry,
Yes,
I'm trying to carry out a comparative exercise. It's easier for us who have got electronic bundles, but nevertheless, the comparison there is unable to place weight in comparison to unable to take into account. Is that right?
So 97, my lord.
No. I'm sorry. I'm looking at the moment 101.
101 is
It used to be unable to take into account, and it has become unable to place weight.
I was right, there is a change there, yes. And then,
Just pause.
and then
Wait.
Sorry.
we all look at the same document. I'm looking at page AB 1016, which is the compare document, which actually does all this for you. This is something I think I got in the process of deciding the application for permission, because I was trying to do what my lord is attempting to do with some difficulty.
Well, I'm getting there.
Yeah, so that's those pages are the comparison. The structure.
Right, so thank you, that is helpful. So we can now go on. You were going to 102, were you?
I was going to 102, my lord.
Right, which has had quite a bit of surgery.
Where the change is more substantial, most substantial, and rather than is not material,
It's not material.
we then have
Is not required to be taken into account.
not required to take into account my policy.
Right, well,
And
hold on.
Yeah, and it's not in the Secretary's view, otherwise, obviously, material Secretary's decision, reasons set out above. So, I want to describe that below as being a lawyered change without his pejorative references to myself and other members of the profession. But what that text is doing is saying, well, actually, it is capable of being material, but it's not obviously material. And that's a change from being said to be not material. And my lords, that is a recognition when that was prepared that the initial draft was wrong in saying it's not material, and this could have taken into account, but didn't. Now, the final draft was sent. This is the final point, my lord, I need to make my submissions. The final draft was sent to the minister for information only. It wasn't drawn to his attention that this change should be made. There's a suggestion in the Secretary of State skeleton that, well, if there had been, that the minister would have spotted the change. I learned a friend, Mr. Westmoreland Smith, at page 70, paragraph 76, The Minister has shown the final draft which clarified this. Although for information if it did not accord with his understanding of the advised decision, he could and would have said, well, the Minister's been sent a lengthy final draft for information. Not been drawn to his attention that some of the text has changed. Ministers have got, what I expect, far more to do than simply to go down and do, that's the exercise which we've just been doing, of a comparison between a document they've looked at and the final version of the document to work out what's changed and to take a view as to whether or not they think that's significant.
It might be said that the officials didn't think there was a material change, otherwise they would have drawn it to his attention.
The point is, my lord, that the officials should have drawn it to his attention. Well, actually, our advice on this point has changed. You can take this into account. We think it doesn't take you anywhere, and the Minister can take a view.
Right, but this is really in the suburbs of the question, which is what do we make of the meaning of the draft?
Yeah. And
I just wonder whether somebody reading it who hadn't spent years in planning might just not say to themselves, well, they're telling me I shouldn't let it influence me because it may not materialise. Not because I'm legally incapable of taking it into account or I must be careful of the word's weight. It's just sort of, oh, I see, it might not happen and therefore I shouldn't say, don't give them this development, let's hope something else might happen somewhere else. And you may or may not do that. If it's like that, if it's as general as that, don't let this influence you because, and it's the reasons that the Secretary of State or the Minister is going to focus on, rather than the fine distinctions between material, obviously material weight.
Well, my lord, it's an important distinction and not just a fine distinction because it is between the officials advising, look, it isn't a point that should be considered a point. Taken by the examining authority to a point you can't consider. And
can you really stop at the sense there? Because they give reasons why in all of these they seem to say because the capacity may not materialise. That's the thing that they're driving at, isn't it? That's the thing that the Minister is being asked to focus on. This may not happen. Don't refuse Manston because of Luton or Stansted, because those may not happen. Not because you can't, because it's too speculative.
I know they do say it's because you can't, because they're saying it's not material, and they distinguish that from. I don't spend time particularly at 1 o'clock going back over what I said, but they distinguish that from the situation where they are saying, well, actually, we should attach weight to the Azimuth report and take a different view. They very clearly distinguish between matters where, look, we disagree with the XA, and this is why we should go around a different route. Matters saying, well, the XA, you can't take into account that approach of the XA. But is it clear?
Had you finished, in fact?
I have even for the electronic steer to do.
Attention, please. Attention, please. This is the Incident Control Officer. A report has been received of a suspected fire.
We're going to
in the
adjourn
main
until 2
building.
o'clock. And
This is
when
being
we come back,
investigated
anything
by
else
the
that you need to say
security
about
fire
this?
team.
And also paragraph
All
265.
fire evacuation and
Thank you.
first aid officers to alert status. Please stand by for further announcement and obey the instructions of your local